So, today we're going to tackle one of the most serious and, frankly, emotionally difficult topics in the legal system: birth injury claims in Scotland. We're going to walk through the journey families have to take from the very first moments of understanding the harm all the way to seeking justice for what is so often a lifetime of care. And I think it's so important to start right here with the human story, because behind every single legal argument, every medical report, there's a family. A family whose whole world has just been turned upside down by an injury that never should have happened. Okay, so where do we even begin? Let's start by really understanding what a birth injury actually is and just who it can affect. When we talk about birth injuries, it's not just one thing. They really fall into two main camps. On one hand, you have these truly devastating injuries to the baby, things like brain damage from a lack of oxygen. But on the other hand, you can have profound harm to the mother. And that can be physical, like a catastrophic hemorrhage, or deeply psychological, like PTSD from an incredibly traumatic birth. Now, cerebral palsy is probably a term you've heard before, and it's one of the most common outcomes of a serious birth injury. What's so critical to understand is that it's very often caused by something specific: oxygen deprivation to the baby's brain during delivery. And that specific cause, that lack of oxygen, well, that's what so many of these incredibly complex cases hinge on. Okay, so we've talked about the medical side of things, but how does this translate into the legal world? Because it's not enough for something terrible to have happened. To have a successful claim, you have to prove negligence. And in Scotland, that means clearing a very specific and very high hurdle. And that hurdle has a name. It's called the Hunter v. Hanley standard. It's a legal test that's actually been around since 1955, but it still governs every single clinical negligence claim in Scotland today. So what does that actually mean? What does it take to prove a case? Well, it breaks down into 3 steps. First, you have to show that there's a normal, accepted way of doing things. Second, you have to prove that the doctor or midwife didn't follow that practice. And third, and this is the part that makes these cases so incredibly difficult, you have to prove that no other reasonably skilled professional acting with proper care would have done the same thing. It is a really, really high bar to clear. But here's the kicker. Proving a mistake happened? That's actually not enough. You also have to prove what's called causation, that the mistake is what caused the injury. A common defense you'll hear is that the harm was just a tragic but unavoidable complication. So proving that direct line, from mistake to injury, that is a massive, massive challenge. So knowing how high that legal bar is, how on earth do you even start to build a case? Let's get into the nitty-gritty of the evidence you need and the experts you have to assemble. Well, it starts with a mountain of paperwork. And I mean a mountain. We're talking every single record from the entire pregnancy, the labor, the delivery, all the way through neonatal care. And see those cardiotocograph or CTG traces? Those squiggly lines that track the baby's heartbeat? Honestly, how those were read and interpreted is so often the absolute core of the entire legal argument. Right. So, once you have all the records, you then have to assemble your team. And we're talking about a whole squad of independent experts. It's not just the obvious medical specialists like obstetricians and neurologists. It's also people who can map out the future. Experts like occupational therapists, care consultants, and even architects who specialize in adapted accommodation. Just to give you an idea of the sheer scale of this, it's not uncommon for a single complex case to need reports from more than 10 different specialists. I mean, think about that. Each one provides a crucial piece of this giant, intricate puzzle. Okay, so the case is built, the evidence is there. Now the journey takes a turn, and it starts to focus on compensation. And really, this part is all about one thing: securing the financial support needed for a future that has been completely and permanently altered. Now, one of the first things you have to understand here is the timeline, because there are strict legal time limits. A mother has 3 years from the date of the birth to start her claim. But for the child, that 3-year window doesn't even open until they turn 16. And that delay for the child's claim, that's absolutely critical. It gives everyone time to really understand the full extent of the injuries and what their needs will be for the rest of their life. You often see these huge multi-million-pound figures in the headlines, and it's so important to understand what that money is actually for. This isn't like a lottery win. This is a carefully, meticulously calculated amount of money that has to last a lifetime. It has to cover round-the-clock care, specialized equipment, adapted housing, and all the earnings that child will never have. And if you look at this chart, you can see exactly where that money is allocated. Look at that huge slice for future care. That's the biggest part by a long shot. There's also a smaller part called salatium. That's the legal term for the pain, suffering, and loss of quality of life, which in these cases is just immense and lifelong. So, when it comes to actually receiving that compensation, there are basically two ways it can happen. You can get a single lump sum, but then the family has the massive responsibility and risk of investing that money to make sure it lasts a lifetime. The other option, periodic payments, completely removes that risk. It's a guaranteed, inflation-proof payment every year for life. It provides total certainty. All right, for this last part, I want to zoom out a bit, because at the end of the day, this whole process is about so much more than just a legal claim. It's about putting a system of lifelong support in place and hopefully finding some measure of justice. Now, whenever something serious happens, the NHS does its own internal learning review. And that's a good thing. It's designed to figure out what went wrong and prevent it from happening again. But, and this is a huge but, it is so important for families to understand that this is not a replacement for getting their own independent legal advice and their own expert evidence. They are two very different things. And this really brings me to a crucial point. No family should ever have to walk this path alone. The support network you build is everything. It's that combination of a specialist lawyer who knows this area inside and out, incredible charities who provide practical help, and the emotional support you can only get from other families who truly understand what you're going through. And really, that's what this is all about. That's the end goal, right? It's for the legal system, when navigated with the right expertise, to deliver an outcome that doesn't just put a number on a tragedy, but one that truly reflects and provides for the enormous, lifelong human cost of that injury. So I want to leave you with this question to think about. For the families who have to live this reality, how do you measure justice? Is it really just about the number, the pounds and pence? Or is it something more? Is it found in the security, the dignity, and the quality of life that a lifetime of proper care can bring?